suit or a dress. It could also be if they've put a label on the material. For example, we all know those big brand names like Louis Vuitton and Gucci. That would be their trademark. So one piece as well can have different intellectual property rights.
I see. Okay, that's coming together for us. So, for example, I mean, Sabrina, you could also, let me know your thoughts on this. You know, if as a creative, what would be that first step to deciding what it is that I use as my copyright? So Chanel spoke about, if it's a trademark or if it's copyright. How do I decide? How do I know what my work will fall under? So if I'm a writer, I'm a designer or a musician, how will I get that information, and what's the next step, Sabrina? Could tech support unmute Sabrina for me so I could hear her lovely voice explain this?
Awesome. Thank you so very, very much. Well, the truth is, I wouldn't recommend that anybody limits themselves on area. I don't know if everybody else. What I work with, primarily, it spans across so many things. As you can see, Bob Marley is pretty much on many things. It's clothing, it's masks. We have masks. It is music primarily. That's where copyright comes in. Shoes and jewelry and everything. So I wouldn't recommend that anybody sits and says that, I have this idea or this brand that I'm going to develop, because of course, you can have intellectual property on a name. And so you have that when you're thinking, oh, I'm just going to do some t-shirts. I would say when you're thinking to start up, you definitely look at what are the possibilities. If it is that you say, yes, I'm going to do some t-shirts and, it's going to be, for argument's sake, Bob Marley. But maybe I could possibly do jewelry as well. Maybe some caps, maybe some, so there are different areas as was shared with us by Chanel. And I would say, don't limit yourself. Think of the possibilities, because that's a mistake that a lot of creatives make. They think, I'm going to do this, and they register, or they get registered in one area. And then when they check, there are persons who come on, see that their brand is building, and go ahead and register the same brand in another or different sections. And then they now have to pay them licensing fees to use the name to what they want to do and make money. So in terms of the steps, the first steps, to be honest, or for me, I don't really deal with that area. It's primarily our legal team that deals with that. So, I mean, maybe representative from Jaipur could definitely tell what the first steps are in terms of getting it registered.
Okay, so we're definitely welcoming Marcus to the chat. Can tech support unmute him so he can help our creatives know what the first step is? Because I mean, I'm sure they have all of this creative energy and they say, okay, I want to protect this part of my music. But what we're hearing is, don't just think about if it's your music or if it's your art or if it's the clothes that you've created, not just that one aspect, but all the different things that can branch from that, because you're now thinking about a holistic brand. Is that what I'm hearing? So protecting all sides of that brand.
Yeah, look at Sparks, ZJ Sparks. She just made one comment and it went into t-shirt and all kinds of wear, like really. So yeah, don't limit ever.
So creatives, we're hearing not to limit yourself. We're trying to get Marcus to join us to talk about, pretty much how do you get started. I think we're having a bit of a technical difficulty with him unmuting. Is Helen with us? Maybe she can also share some of her knowledge with us. I'll try to have tech support unmute her. But in the meantime, as we get her on here, we spoke about licensing. You said, persons can, you go and you get a copyright for one side, but then somebody else goes and does for the others. How is that even possible? I'm sure creators are probably even thinking about that. How is that possible, and how do they protect against that?
My name Savio, while we get one of the first things you want to do is start out by researching. It depends on the type of property you have. If you have something written, you have music or anything like that. Copyright tends to be automatic. Once you can document and prove there, and Marcus and Carmoni comes on. Right now in Jamaica, there is no formal process to register copyright, and Shani can depend on that. But and people will talk about foreman copyright, where you put something in an envelope, mail it to
open it.
Yourself.
Don't open it, that kind of thing. And or nowadays I practice digital foreman thing where you have some files and files become dated. I don't erase those files. Put them on a jump drive, put them on a CD, but make sure you put them on a media that can be accessed, because you want to keep your information or format that you can access. I have stuff on zip drive. I don't know who remember zip drive. And I can't access it, so those are dead, I can't prove it. But anyway, so that becomes automatic. The other forms of IP, such as trademarks that you've heard about, industrial design and patent, those are formal processes. And a part of that will start with some research. Trademarks are what people use to represent their brand names and stuff. So I come up with a brand name, Volcano Graphics, for argument's sake. I have to do some research first to find out, is anyone using that name Volcano Graphics? Even if not Volcano Graphics, anybody in the creative sphere would have something similar. Volcano fashion, Volcano food, Volcano this, Volcano that. And try and get something unique. In the early part of the stage, and I know I'm a creative as well, we get extremely defensive and jealous about our names. I want to hold on to it, and it may not work for us, and we stubbornly hold on to it, and it's not working, and we hold on, and it's not taking us anywhere. So learn to loosen up a bit and so on. And of course, you go through the process, you engage JIPO, you engage an IT attorney, and they will help you with further research and then take you through the registration process as you go along. So those are the stages I would suggest that one takes. But also think carefully while you go through all of that. Let me, and we're going to want to share ideas with people. Be careful of who you share ideas with, obviously. And when you're sharing ideas with persons, ensure that you have some other form of proof that this is my idea, is where it starts from. I know dancers who will turn on a video camera in front of them and they start showing their dance moves and even writing it down and so on. So dance you can record in different kind of ways and the steps and so on. And then
so give me an example of how I would do that. So for example, I'm a dancer and I just come up with the dance called fried rice. Okay. So we're all here and I come up with the fried rice dance. Right. How do I make sure that in that video with my 3 friends who I think are my friends, that them don't thief my fried rice dance and go make some money off of it?
So I'm not a dancer and I don't know if dancers do this, but in my mind, this is what I would do. I would obviously give a little bit of narration of what I'm doing, right? I would say, okay, here are the steps. 1, 2, 3, 4, turn and spin, jump in the air, left foot lift 2.5 inches off the ground, that type of thing. So you go through that and you describe what you're doing. You're not just stand up and dance, you're moving where people can't discern the different steps and moves and why you think it is different and unique and so on. And then what I would do, my background is engineering, so I like to write down stuff and I like to sketch and draw and make specifications. So just put down even some dots. Left foot here is 1, right foot here is 2, left foot go here is 3, right foot here is 4 to show the movement. And that can become the basis of how you start documenting that dance, that particular dance. You know, of course, you'll have to test it out with other people and so on. No, so validate that, yeah, this is original, no one has ever done it before, or even if it takes from something that existed before, you highlight the unique part of it that can be determined that this is unique, I came up with it.
Oh, I see. And thank you for joining me, Marcus, because I mean, they heard it first here that I'm coming up with a dance called fried rice. So I want you to help me to know So, I know there's a rice and peas dance or some other dance, right? How is it that when I come to Jaipur and I say, hey, I have this thing I want to copyright or trademark, how do we identify what are those unique features of it so that it can be differentiated? Like, what is the process of a creative coming to say, hey, I have this thing, I think it's unique to me, I want to make sure nobody else can access it? What's that process?
All right. Well, thanks for having me, and even to all my fellow panelists and your audience. So yes, I mean, basically, originality is where it's at. So you'd have to be able to establish that what you are coming with is not already, being done out there or not being done in the same way. That what you have added to it or come up with is original to you, in some respect. And so how to ensure that what you are doing is actually original in a copyright context? Not always easy, right? Because copyright doesn't have to be registered. So people can, use and have it protected without it being registered across the globe. So it's really about, I think, doing some research into your area. If you know you want to come up with a new dance, you probably would have to go and look and see what are the existing dances out there already, to make sure that what you have in your mind is different from what has already been done out there before, And I mean, generally with IP rights, it's good to know what's out there in what we call the prior art, what's out there in the space already. So that when you go to work on something, whether it be a design, copyright, patent, song, whatever, you know what you would need to do now to tweak it or to create something original from what is already out there.
Okay, I got you. And thank you
Tammy,
for
if you'll allow me,
Go
I
ahead.
would just add to what Marcus is saying, and Colin, of course, is that it's very important to know what's in the space. Because you might think you thought of a new idea, but when you do a quick Google search, there are 10 other people using the name that you wanted to use. And then you end up using it and you end up infringing somebody else's intellectual property rights.
Right.
So it's very important to do a full clear on search, especially if you're serious about the brand that you're about to create. And as Colin had said earlier, that if you need to go and make a small tweak to this name that you're so hung up on, you have to make the change to create your brand and make it something for you and not what someone else already has.
Is that a part of the process, Marcus, in terms of when I come to trademark or copyright? Is that a part of the process to then go do another validation to check to see? Because I've done my research, I come. Is there a process to say, okay, what you just said, Kavio, you check to see if this exists as this fashion or this game or this art, but we're seeing that it actually does exist. Is there a process for that? And how does that work?
For trademarks, for sure, right? So because trademarks, we have a trademark register here at Jaipur. And so if you do want to know what's already registered, you can come and do a search, and find out. And certainly when we go to examine your trademark application for registration, we're going to check our register to make sure that what you want to apply for is not too similar to or the same as what's already on the register. Well, I say for copyright, it's not so easy because we don't have, that kind of register that would be or would serve the same purpose. For design and for patents, yes, same thing. You can search the register to know what's already there, but we also do tell people to do a search outside of that as well. Search online, search Google, search your general websites, search your local marketplaces as well to make sure. But of course, again, I'm saying that, it starts with you being able to be sure that what you are presenting would meet the criteria for registration.
Okay, and for the purpose of those just joining us, we're talking about intellectual property, what it is, and as a creative, how it can benefit you. And Helen was just about to give us some gems, so please.
No, I was just saying, just to add to Marcus, I think it's, just to say what he said is very important in that it's not just about the Jamaican landscape as well. You have to look globally, what exists on the registers globally, because there's the Paris Convention Treaty and all these other countries have signed up to it, and their trademark, even if it's not registered in Jamaica, by virtue of them having registered their trademark in one country, they're afforded protection in Jamaica. So it's very important when you come up with an idea to do your what we would call due diligence to make sure that you be cleared to use it and not have in the potentially a suit against you for passing off infringement, etc.
Okay. So
Sorry, if I may add to that, it's not just about even, I mean, while it's important with the treaty, it goes back to my point that says if you intend to make your brand as big as it can be, then why would you want to have the same name as somebody else in Australia? You get what I mean? Because if you are able to do a franchise in Australia, for argument's sake, then you would want to, because I mean, it's business, it's money at the end of the day. So definitely have to do global search when you're checking.
So for a creative who is listening now and who has never copyrighted anything or have never done anything with trademark, if they're thinking, what's the difference between trademark and copyright? What would we tell them? And, it's a twofold question. So it's, what's the difference between trademark and copyright? And then as a creative, how do I know what I should be protecting?
Shanu?
Yeah, I'll take that one. So let me start with the easier one first, trademark. So under our Trademark Act, it's defined as a sign, and then a sign goes on further to define that it can be a name, it can be numbers, alphabets, design. So automatically when somebody hear about trademark, they automatically think of your logo or your brand name. Those are the things that we tie normally directly to a trademark, or maybe a slogan. When you think of copyright, on the other hand, it's more like your literary works, your dramatic pieces, music. I don't know if there's anything else I'm missing, but generally that's what copyright falls into. It's normally easier to identify trademarks than copyrights because, as I said, you can look on a logo and say, yeah, that's a logo, that's a trademark. But as Marcus said earlier, when it comes to copyright, you have to first figure out what you're doing. Is this original? Is it something that you created and you're not just trying to reinvent what somebody already had? Most creatives will easily identify a trademark more than their copyright. From experience, it's easier for people to reach out to someone else, whether it's Jipe or their attorney, to ask them, does this qualify to be copyright or does it qualify to be something else? So
I can
quick examples.
also add, Shanil, copyright would include things like photographic works, some works of art, your paintings, your drawings and stuff. I know some drawings can also be trademarked as well as enjoying copyright protection. But pretty much, those, or the originality has to be there, as you've been hearing.
So to add to that, one of the elements of it qualifying for a trademark is that when somebody sees it, they are to be able to distinguish your trade from somebody else's trade. So that's how something will get protection. Can somebody look at it and then automatically associate it with a particular person or entity's business, etc.? So that you have to think about that. If you're going to come up with a trademark, it should be so distinguishing that somebody can say, oh yes, they're located at so and so and so, and they sell shoes or they sell clothes, they sell handbags. So that is what you have to keep in mind when you're also coming up with a trademark.
I see. And then
a suggestion, let me just add, a suggestion I normally make to people general, not just creative, is that when you think about intellectual property rights, you first ask yourself, which one of the intellectual property categories do I fall under? And as I said earlier, one item might have several rights attached to it. So your one item could fall under both copyright and trademark, or an element of that item could be separated to have two different intellectual property rights protection. So as Sabrina had said earlier, don't try and close yourself off and say, well, I think this is only trademark, so let me just stick with trademark. That same item could have some protection under copyright or patents. So it's always important to think of it on a wide scale and ensure that you cover all your ends.
And it's not time for questions yet, but I think because of what we're talking about, someone from YouTube is asking, to what degree would they have to change a design to make it different for it not to be considered a copyright infringement? And can I be previous to say, based on my little knowledge of intellectual property from all you amazing panelists, I would say any change you need to make needs to be distinct. So it, however much change that is to the level that it's going to make it distinct from the other one. Am I right?
You're correct. And
Yes.
as long as people will not confuse one for the other and assume that they both belong to the same person. So that distinction has to be also very clear and obvious in my mind. So, and there are people, you have a brand Nike. And then you'll have someone who creates a shoe and call it Nike
Or swoosh.
or swoosh or swash or something, and they
Nice.
put a little bump or a circle at the end of the swoosh. And,
Yeah.
But Nike is different from Nike. No, that don't work like that, So the distinction has to be totally different, totally clear.
And now that I've understood that, listen, I need my thing to be different. Okay, it's different. Now I get into this whole thing about licensing and how does that apply to different creatives? So if I'm a gamer or I'm a artisan who, makes certain other things, I'm an artist or I'm a fashion designer, how does that licensing apply to me as a creative? Could we, give specific examples of how licensing would apply?
Ellen, you want to go ahead?
Okay, so I'm going to use examples. So for instance, you could have a well-known manufacturer of goods, like let's use Ocean Spray, for example, right? So, everybody knows Ocean Spray trademark, etc. So they've registered their trademark, but you want to sell Ocean Spray in Jamaica and not infringe their rights. So you go to Ocean Spray and say, can I use your trademark? I won't try to pass it off as mine. I want to sell your brand. I want to use your trademark for advertising purposes, etc. Can I get a license? So Ocean Spray will say, okay, that's fine. You're going to pay me X amount of money for the use of the mark. And for, perhaps they'll say for every million product that you sell, you're going to give me X percentage. And then those are the sorts of details in a licensing agreement. And then they'll put it in writing, both parties sign. And then you're going to give the agreement to your lawyer. Your lawyer is going to go to JIPO and say, please register this license. In other words, this person is allowed to use this trademark for these purposes. And then JIPO will put it on the record, and then you won't be liable to, for someone to say, oh, you pass it, or you're using Ocean Spray's trademark illegally, or, you're infringing their rights. So that's how the licensing works. So you, in a copyright context, you write a song or you write a melody, and different artists want to use the melody. So you record it with or you register the melody with JIPO, and then you have agreements with people. You say, okay, all right, you pay me X money and you're allowed to use this melody, and you put it in writing, and then you register that with JIPO. So that's how the licensing is relevant.
How do I know how much money I should charge for?
So before you jump to that, Tavio, I just want to use the time right now to really clarify or add to what Helen said for people to understand the terms, the difference between registration, licensing, and assignments, because a lot of time people come and say, I want to license something, but what they mean is they want to register something. Or they come and say, well, I've assigned my right to somebody, but what they've really done is license their rights. So it's very important to understand the three different terms. Registration of the trademark or the copyright or any intellectual property is registration with JIPO, according to whatever statute applies. When you speak about licensing, this is when you know that you are the proprietor or the owner of that intellectual property. And as Helen said earlier, you give someone else the right to use it, but you maintain ownership of the mark. When you assign your intellectual property rights, now you are basically like selling the property. You're saying, I'm no longer the owner, I'm giving this all to you and you own it. So it's very important to distinguish registration, licensing, and assignment. When it comes to consideration, now maybe Colin or Sabrina can assist with that.
Yeah. Well, what I want to add about licensing as well, it's important for you, the whole of the IP, be very clear on how your licensee should use your property. They can't alter it, as Helen started explaining about Ocean Spray. So they can't alter the look of the property, whether it's color, form, shape. If it's a beverage, you can't change the formulation, anything. So it's important for you, the owner, to be able to define your property clearly as well. To say, okay, I'm licensing my property for you to use on a t-shirt, on a bag, on a cap, but here are the parameters in which you use it. You can even go as far, and the attorney here will tell me how many units I'm licensing you for you to reproduce or to use it for, and for what purpose. And if they use it contrary to the terms that we agree and that would have been in the agreement that Helen mentioned, then you can take them to court or where and say no, and quite that license from them, you know.
Okay. Thank you for that clarification. And I know Sabrina had spoken earlier to the fact that creatives should ensure that they're not just putting themselves in a corner and just say, okay, I'm going to do this one thing, but they can spread it out. So for example, I'm a visual artist and I've created this piece of art, and this piece of art can be represented on a phone case, on a pop socket, on a cup, on a shirt. How do I ensure that if I'm not going to be the one to put it on a shirt and a pop socket, but I can give out those licenses to other people, how do I make sure that I protected myself from the start to allow me to have persons create those other products from this piece of art that I'm creating? Because I only care about visual arts, but I love the money that comes in from the other things. How do I make sure I set that up first when I'm, sorting out my business?
Well, the actual process of setting it up is the same. I'd imagine it's the same registration process, but it's just a matter of selecting the categories that you'd want to ensure that your design or your visual art is represented in. So you'd have to, and then with visual arts, in terms of like film, for argument's sake, is a little bit more tricky, because especially animation, there are so many elements, like different characters that you might want to ensure are registered, because as they become bigger, somebody just might want, for example, Marvel, they have so many characters that they have to account for, and it's not just the heroes, it's the villains. It's because people are so different that you'd imagine somebody wants to represent the villain. But it's just ensuring that it is accounted for in the categories that you want. So whether it be clothing, if it is that you want to do jewelry, if you imagine it there. We're creatives. We can dream big. We can imagine endless things happening. So just try to apply that to your brand or your design or your creation, and say, where can I see this? What corporate entities, for argument's sake, too, might want to use this, and how would this apply to them? Because something as simple as, for example, somebody doing a painting, and then Digicel comes along and says, I want to do a limited edition run of your painting on my cards. Those are the things that you want to ensure that you cover your brand, and that it cannot be used out by anybody else other than you in those categories.
And there are some persons who would agree that the Marley brand has captured that in its truest form, in ensuring that any aspect of how it is used is guarded and protected. Do you want to talk to us a little bit about that, so that other persons can see it in real example of what you're mentioning, of thinking outside of just what's in front of you? Could you share, some experiences with us about, that brand and how they make sure to protect their intellectual property?
Well, firstly, our amazing New York team, they work tirelessly with our legal team to ensure that the brand is protected in every aspect, starting with his music, going down to his name, his image, the likeness of his image, etc. Like, everything is pretty much covered for Marley. From there, we go into licensing. We do a lot of licensing, whether it be for clothing, and we ensure that we are very clear as to the territory as well. That's something that we haven't spoken about, but we are very clear as to the territory that is allowed. So you may see a licensing partnership for example, what's out there, Marley Coffee, but the person who has the license in Jamaica might not be the person who has a license in Chile, for argument's sake. So it's many things. We have so many merchandises. We have there's film. There's using his music in film as soundtrack. We have one that's about to come out in June. You know, the latest drop that we've had are board games. You know, who would have thought that you'd be doing a board game of Marley on tour? You know, it's just throwing dice and seeing where you reach, whether you land in Zimbabwe or Ghana or wherever. And then, of course, there is the major investment of ensuring that our tourists experiences legacy as well when they land here. So the Bob Marley Museum, where I sit, is another thing. You know, it could have been, what if the family didn't want to retain this? What if they wanted to just hand it off to somebody as a license and say, hey, you can hold this, but, you know, give us this cut, as Helen was explaining. But those are a few of the things that's in Marleyland. But it's pretty wide and it's a lot.
Well, thank you for sharing that with us as a real example of what it means for a creative to protect their brand online. And if you're just joining us, we're talking about intellectual property, this thing called IP. And it's so important for creatives because we're in the world of online. We're in the world of everybody doing everything and taking ideas and just going with them. And as I talk about online, I mean, maybe we can talk a little bit, Helen, about what would happen if I were to go online and not protect my intellectual property? What are the actual dangers of that? Because maybe we're not, you know, we talk about the poor man's way of doing it, you send it to yourself, you don't feel like, but what are the real dangers out there?
So, you know, if you're a well-known brand, it is very likely that even without registration, you can still have some protection. However, what registration does is just, it makes enforcing your rights so much more easier. So if you have gone and you registered your mark and you see somebody else using something very similar or identical to it, immediately you can go and you can, you know, start court action based on this registration that you have. Or if you see somebody trying to register a mark that you have, or that's very similar and identical to yours, immediately you can oppose the mark. You can what JIPO what I can't remember which form it is, but JIPO has a form, notice of opposition, and you put the details of the opposition and then you submit a grounds, and part of those grounds is that, well, I have this registration and so I have a prior right. So if you don't have these registrations in place, it just makes enforcing that much more difficult. It creates more of a higher burden of evidence that you have to prove or show to say, well, this person ought not to be able to use it because I created it. You know, registration is just a way of enforcing those rights. But that's not to say you can't if you've not done it. It's just that much more difficult.
And Marcus, you know, I'm new to this whole intellectual property as a creative and as an artist or a singer or a fashion designer. And all of this sounds good. And I want to protect my brand, but it's overwhelming. It's a lot. Is there room for me to be able to come to JIPO and you can give me a little, you know, schooling so that I don't feel like I'm going into a world of Google to try and find out all of these things? I feel stressed out just hearing all of this as a creative, for argument's sake. Is there an opportunity for me to have that, you know, easier transition into this world of intellectual property?
Yes. I mean, so of course, you know, being a government agency, JIPO is here, you know, tasked to ensure that the wider population appreciates the importance of IP rights, you know, for themselves and for national growth and development, right? I mean, I think that it's incumbent on creatives, you know, to take the time though to try and learn this thing, you know, in a meaningful way, because of course, if you don't, you're going to make some mistakes and stumble and probably have some pitfalls, you know. So I know that it's always discouraging for persons when they have to contend with all of this IP registration, documents, and the business of creativity, you know. But if it is a career, if it is an investment, it's worth it. And so while we can, of course, help and guide, we do a lot of public awareness. This week is IP week. Well, really starting from today into next week is IP week, you know. And so we do a lot in that regard. But there is a lot that you can also do yourself through online research. And I mean, you have to go and Google all around. Start at jipo.gov.jm, right? Where we have a lot of information there about what we do, about the procedures, the forms, the cost, and so forth. And of course, we have a wealth of information also available through our able IP practitioners at the private bar as well. And so, we're here to help. But of course, I think that when you have the knowledge under your belt, you're better served in the long run.
Okay, so Curtis, you hear it? Don't stress out yourselves. Go to JIPO. They will help you. But you also have to have that passion to want to protect your brand and to also build a brand that is bigger than our beautiful island here. It's a brand that can go international and be protected just the same. But
I do see a question in the chat directed to Jaipa about film copyright in particular. I don't know if, I guess I should just say something.
You had spoken a little bit about it or
about it. Okay, cool. All right, cool.
I wanted to ask, is this something I need to save for? Like, how much do these things cost? Like in real life? So I'm a crafts man, or I'm an artisan or a musician or a fashion designer or whatever it is I do as a creative. How much money I need to put down?
Not that much for registration. No. I mean, certainly for copyright, which is probably the newest one we have available for registration. Again, it's not compulsory, it's optional, but you can register, for example, an album of songs, up to 15 songs for like $3,000, and of course, this will last for the entire copyright period of time, which under our current laws, the entire lifetime of the author plus 95 years thereafter. So that $3,000 will be able to serve not only you, but probably your children and grandchildren as well, as Bob has shown us, right, Sabrina?
Yeah.
So, it's
very,
very affordable and worth it. $3,000 for the copyright, for trademarks, a little bit more for trademarks. Probably you pay like 20 grand for a trademark for a 10-year period of protection. So 2,000 Jamaican dollars per year for protection for your legal brand. I think it's very, very, very affordable.
I was just going to say, Sabrina, that I love how him break it down. He's like, listen, it's just $2 grand. Like,
it's simple maths.
And remind them, Marcus, you don't pay the 20 grand one time. You pay.
And you don't pay the 20 grand one time.
And it's
exactly. Thanks, Colin.
For other class, Marcus.
Huh? Yes, so right. So I mean, it can be a bit more, but I mean, I would say 20 is, and even 20 is not the cheapest. If you have one class, it's going to cost you $17,800. So it's really affordable, and it's really part of your business plan. Yeah,
and the classes we're talking about is if, let me go back to a practical example, is if I'm a visual artist and I want to use my thing on a phone, on a cup, on a shirt,
right,
on a car, vinyl. So those things probably would be in different areas.
Right.
Yes.
Correct. So for trademark specifically, when you're registering a trademark, a part of the registration process is to identify the class and list the goods and services to which the trademark will be aligned. So you can say that you're using the trademark in financial services, or using the trademark on T-shirts or calendars, or you're going to use the trademark on a bottle of lubrication or fuels or gasoline. So you have to identify the class, which is what Marcus was indicating. It's important that when you're registering for your trademark as well, that you try and identify all the applicable classes from the get-go.
Right.
So Jamaica is one of the few jurisdictions as well that have multi-class registrations, which means that you can have one registration for a trademark and you apply for all the classes in that one registration application. So as Marcus said, you just divide that by 10, it's really only like $2,000 a year. So you just make the investment and make the lump sum payment in 1 year, and for 10 years you're protected, and your brand is going to grow so much in those 10 years.
It's true.
All the possibilities.
Important part, which is what a lot of people don't look at. When I pay this 20 grand for my trademark now, and I have 10 years in front of me, the value of that trademark will grow, right? So that $20,000 multiply in terms of return to you many times over, and I mean, when you calculate the value of the protection it will give you, people can use your name. You can use your name and your product in so many different segments of the market and so on. It really is a win-win situation. It's one of the best investments you can make.
True.
Yeah. So if I were to, let's say there are 10 classes, for example, for this product that I've come up with, or this idea, if I afterwards think, you know what, maybe I could add it to that and add it to that, can I come back and add additional classes? How does that work?
No, you can't. You can't. And again, it's a global restriction. It's a Jamaica or Jaipur restriction, a global restriction that you should really from the get-go know what you want. And I guess when people come to search or register, right, they search and find, and what they see is what they will plan for. And so the rule is that if you want to know, expand, you have to file again. And as Chanel said, therefore, it's best to really think ahead of time from the get-go to know what you want to do with your brand, even 5-10 years down the road.
Well, I will qualify that statement just a little bit. Not to say what Marcus is saying is incorrect. It's correct, but let's say you filed a month ago and the application is undergoing the process at Jaipur. It's being what we call examined, where they're looking at the trademark to make sure it's not, it qualifies for protection and the goods are acceptable, etc. If a month from now you said, oh, but you know what, I really should have added t-shirts to it or flip-flops or something. If the application hasn't gone too far ahead, at that point you can still make an application to add it. So, if you're quick enough, you can add it. But once the mark is published and registered, you have to file again at that point.
Which means that in layman terms, I'm starting over from scratch. So if I just paid...
Not really.
Not really.
You would have been familiar with the process already. So, filling it out will be quite, just...
No, when I say start over from scratch, I mean, let's say I paid $20,000 to trademark for all the classes I wanted, for argument's sake, and not making your money small, Marcus. I paid $20,000. Now, I come back and I realize, I missed out 5 classes or 5 things that I could have done with this. Do I now need to pay back that original amount plus these 5 classes?
Right. No, you wouldn't have to. So, you would still have the first registration on the first application, which you wouldn't have to give up, So what you'll be doing is filing an additional application to basically improve or strengthen what you had before.
Okay. Understood. So creatives, what it's also saying is that you have to think about your brand in a bigger sense. So when you're going to protect it, you can protect it all around as you can. I think I saw a question in the chat, so I'm going to just run to it quickly. They were asking Marcus, I think this one for you, if there was a price list on the
website. Yes, it is there. Yes, there's a trademark fee schedule. Yes, it's there. Copyright schedule is also there as well, right? Right now, designs, if you want to register your design, fashion design, new clothes, new hat, new shoes, only cost 1,500 Jamaican dollars, right? For 15 years protection. Actually, that law is going to change soon. So we're telling people, no, if you want to get that price, if I come to Jaipur, probably in the next 2 months, I'm going to say, right? The patent fees also right now are very, very, very affordable because our law is very old. And so I won't even tell you how much those fees are. But the reality is that, again, it's going to change in about 2 months or so. And so these prices are very old, archaic prices, which are very affordable. And even the new ones, I would say, are still affordable. But we have, for a few more months, some old prices, which we want to say to people, get while it's hot.
Guys, so I think you should get it before it gets hot, before it's summer. You should go and take advantage.
I just want to add, Tavia, speaking about registration, I don't want anybody here to feel like, if I don't know what I want my brand to be in 5-6 years, that I can't do a trademark registration. You can always, because the trademark is one intellectual property that you can renew every 10 years. So let's say you register the trademark today and you register it in 2 classes. 10 years from now, your brand would have developed, and at that time when you're going to renew this trademark, you can say, well, maybe I want to I won't say add, but maybe I want to apply for 3 additional classes. So at that time when you're renewing the first mark, you can then make your application to have the 3 additional marks. So don't feel like if you don't have it all figured out right now, you can't go and register the trademark for 1 class. As you have a right, go out there and protect it.
There you have it.
Sorry, just to throw back to the film question that Marcus was referring to. I don't think I answered it. They're asking specifically if Jaipur does the copyright for film. So that might be something for Marcus to.
Okay, Marcus, we can actually go into that right now.
Oh, for copyright. Yes. So yes, copyright registration at Jaipur does cover film, art, music, dramatic works, broadcasting, poems, stories, etc. And so yes, we cover all copyright works for basically that same price range.
Okay, so filmmakers, writers, all of you people, go before it's hot in the summer because the prices are good now, as Marcus
That's
said.
right.
So, I mean, guys, this has been such a fruitful conversation because intellectual property can be a scary subject for a lot of creatives. And it can be uncomfortable because they just want to create.
Yeah.
But as a creative, if you're in the business of it, you need to understand it and ensure that you are in it for the long run. And somebody else will not come when you become a superstar and say, boy, okay, let me go and trademark this because they are now a big brand and they didn't know about anything relating to intellectual property. So I'm taking from what you guys are sharing that it is so important for a brand. But if you were to say to a creative how copyright protection adds value to their brand, what would be, that thing that you would say to them to encourage them to actually want to do it?
If I can start on that one. For me, a creative would have their own DNA coming out. After a while, you're doing this thing and you put your work out there. People recognize your work easily once you're consistent. So they can hear a piece of music or see a dance or something and get, probably TV that dance look like the rice and peas.
Fried rice
or that. Or you're an artist and so on. So you build up this body of work which has some kind of recognition. What you want to do now is to leverage that. So we spoke about the licensing. Of course, you'll be registered and so on. You want to look what best can be used to represent and become a vehicle now to get my work out there for it to be known. So it's a constant thing. You always have to think. For creative, it is a part of your business. It represents your product. It protects your product. So think, how do I market my product? How do I get my product into the hands of the people who I'm sharing it with, who are consuming my product or my service or what have you? And constantly put that out there. While at the back of your mind, this is where you start thinking about how I'm going to protect and police and so on. Because Marcus and Shanil and Helen will tell you, once you protect, that's only one part. You have to start look out for people who infringe on your property now. And don't be shy to say, hey, my picture that you use, I don't get given a permission. Even if it is that they're not going to pay for it, give them credit. Copyright Colin Porter, right? Copyright Xavier Benjamin. This is my artwork on my thing, right? Depending on how they're going to use it, obviously, of course. But in some cases, that alone not going to work. No. You have to get my permission before you use it. If you didn't, take it down, right? So you have to be in that police mode continually looking up and defending your property.
That's right.
Helen, how do we get people into that mode of seeing their work out there and saying, listen, hey, money, or stop that, it's mine. How do I get into that mindset?
Just think money, 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 money. I mean, at the end of the day, that's what it boils down to. For instance, recently, there was this big hoopla about, look at Taylor Swift. Her masters were sold for how much money, and then they were resold for it's purported 300 million US. Why was somebody so willing to pay that much money? It's because so many people listen to her music. It's on all the streaming services. The fact that it's protected, even when she's no longer here on earth, it's copyrighted. Her estate will get that money. If you so happen to be one of the lucky few in this world, and your work is so popular and it's able to generate income, the fact that you've protected it, you've ensured that you will have a pension later on in life. Look at it as a pension. Your children and your grandchildren would possibly be able to benefit from it. So at the end of the day, you put so much effort into this work. Ensure that you reap some of the rewards as well. I mean, that's my take on it.
Don't waste your energy and your creative. At least make some money from it.
Yes.
Oh.
Yeah. Definitely try to make some money from it. And it's not always just being on the defense when no one is around, even when people are around. Don't just see a paper and they tell you in person, oh, this is what the paper says, and sign it. Read the words. Are you assigning your right? Are you licensing your right? Are you giving away everything and you have nothing left after? So you shouldn't come and say, you know, I did a project with this person and I did tell him he could use my trademark or use the copyright. But then when we review the document that you signed, you basically gave away everything, but you didn't realize you gave away everything. And then he also didn't even pay you enough for your protected brand. Be very careful with everything.
So if you don't understand, ask
Seek
the
legal advice.
Yes.
Don't come to the lawyer after it gone bad.
Seek
Come to
legal
the lawyer
advice.
or
Come to us from the beginning. It's always better that way.
All right, so you guys hear it. So listen, if you have agreements as a creative and you're thinking about protecting your work, if you don't understand it, it's okay. You need to get the help to understand it before you enter into any agreements. But what if, for example, I am hired by a client? This is a question from YouTube, I believe. I'm hired by a client to create an illustration. As a designer, can I trademark that? Do I have the right to trademark the design that I've created for them? So they come and say, hey, Tavia, I want you to come up with something for this series that I have. They don't give me any ideas. I come up with everything by myself. I give it to these people. They go and make millions of dollars. Where does that leave me? Do I have any way of making some thousands out of my work?
that comes down to your negotiating power.
Right.
It's
Yeah.
very important from the get-go to have those agreements in place. So that is a contract for hire. So usually for those, when you create under a contract and you're giving somebody that somebody's paid you for your services, you will no longer
Right.
own that. That's generally how it goes. You can modify that agreement. It will come down to how hard a stance are you willing to take? How much do you want to keep that work, you know? So it all comes down to the negotiations.
Okay, and I have a question. Oh, go ahead.
Let me just add to Helen. When it comes to the registration of intellectual property, it's not a situation where the proprietor just has to be one entity or one individual. You can have joint ownership. So if you want to agree with the person that we're going to hold this 50-50, or you want to have 3 proprietors owning this intellectual property, you can also have that agreement. And that may be a good position for many people who are doing startups.
Okay, that's a good point. I see where Ayana has a question. I'd take the question now if our tech support can assist me with unmuting her.
Hi.
Hey.
Hey, everybody. Thanks for having this Zoom. And hi, Colin, that's my old boss. I have a question. I find that a lot of times there are a lot of corporate companies or even like other people that will say, hey, send in a bid and you'll have to do like some work. And like, how do you protect yourself? I mean, yes, of course, you can put the copyright symbol at the bottom of your work or whatever, but most of us creatives, I mean, I'm relatively established and I'm sure there are some younger creatives on this Zoom. Like, how are we supposed to protect ourselves from sharing, whether it's a design, whether it's, you know, because it's a bid to do a job. So essentially we would have to create something to submit. How do we protect ourselves? I mean, of course, there are non-disclosure agreements, but at the same time, I mean, when you're a small fry, power, saying a lot about, you know, like you guys should negotiate ahead of time. But as a small artisan, you don't necessarily have that upper hand to say, hey, you know, like you need to sign this before I submit any work to you guys, you know, whatever it is. And then like, how do you protect yourself?
All right, maybe I can come in on this just to follow up. Since it's a similar question, I think to what we were talking about a while ago, what Helen and Chanel said. So it's going to really, I think, be based primarily on the strength of the contract that you have, with whoever you're doing that work for, and if they come to you to do work for them, then ideally it would be your contract that you would be giving them, right, to sign before you do that work. So how your contract is constructed is going to be then critical. The Copyright Act certainly says that the owner of the copyright work is the author. The first owner is the author, unless there's an agreement to the contrary. And so in your contract now, you would be well advised to have in there clear language that reserves to you the copyright ownership of that work, even if you're doing it for somebody who has hired you to do it. Right? That's very key, because again, yes, you put the C on there and you have your contractual terms. It may be breached, but at least you'd have the legal recourse to go to court if you have that breach. Once you have a contractual agreement where it confirms you retain ownership of your copyright work, right? So you mentioned the NDA as well. NDAs are very useful, right? Again, they don't automatically prevent infringement, right, or copying. And so they may still get infringed or still get breached. And so you still have to go and find some legal recourse to pursue, but at least you'd have something in writing that would be able to have you have a good chance of success with that case if you have to go to court with it.
Right. Just to chime in here, I see where Andrea had shared in the group that sometimes it is an open call and that creatives have to submit the work and to be selected, which means you wouldn't have gotten to the stage of a contract, submitting your own contract, etc. But just as you said, Ayana, to be honest, it really, and as Marcus reiterated, it's really just to ensure once you've sent that email, then it stamps the date of your work, firstly. And then two, don't be afraid. I would say if you do answer to an open call, which we do hear from time to time, don't be afraid to ask, to confirm that if you submit your work and it's not selected, do you retain, will you own the right to your thing? Or is it something, because sometimes when they do an open call, there is a little fine print that says all work submitted to us belong to us. And that's especially so, for example, with a brand like Marley, because if I ask you to do something playing with the image of Marley, then you're not going to retain the rights to that image. You can't just go and use it commercially after doing it. So that's just my little 2 cents on the open call bit.
If I can add to that as well, and a very important point Sabrina raised, but the converse also can work if, for example, you have a very distinctive style in which you do your illustrations and so you can easily say, oh, that's an Ayana creation. And if you're using some element of that in this open call and so on, then like Marcus and Sabrina said, you can be upfront and be assertive and say, listen, this is my copyright thing. You would have already protected it somehow, and read a fine print firstly, and then submit and then communicate if you can. I know sometimes communication is not easily facilitated 2 ways, but this is my property. And here are my terms and conditions as well. And if they don't agree with it, sometimes we just have to back and say, all right, I'm not participating in this. This is not for me. This will not advance what I want to do anyway. So, we have to make that decision sometimes that, okay, I'm going to pass up this opportunity because it's going to expose me too much.
And that goes back to, what we're talking about in terms of how you value your brand. Because you need to know what you want to be a part of or be associated with. And earlier we talked about that NDA, which is non-disclosure agreement. Is it that I know there may be some that run for a period of time. So you say, okay, for a period of 5 years, for argument's sake, you cannot mention anything relating to this. But what if, for example, a creative were to submit something for an open call or wherever that allows for an NDA? Right? And it has a specified time frame. What is their recourse after that time has passed? Is it that now the person who it was submitted to can then say, I'm no longer under non-disclosure, so I can now use your work? How does that work for a creative?
So a non-disclosure agreement generally doesn't deal with the use of the intellectual property content. The non-disclosure agreement deals with the relationship between you and the other entity and what you can disclose or what you should not disclose about that relationship. So that is a separate agreement from the intellectual property rights itself. Non-disclosure agreements are very important documents. Another document that you should ensure you understand the terms in that agreement. Some agreements go to the extent that they don't have a termination, meaning that they go on for as long as intellectual property exists. Some of them may have a termination date, but they may have other rights that would still exist after the agreement itself has quote unquote terminated. So the non-disclosure agreement may also restrict you from creating something similar that you have created for this entity for someone else. So you have to look on the things like whether you can compete with the entity that you're working for, or whether you can work with someone who's in the similar market. That non-disclosure agreement can have so many terms outside of intellectual property rights. But so that's a document that you shouldn't just easily sign because yes, you want to respond to an open call. You should definitely ensure you get that reviewed or you understand what you are signing to. And if you're not clear, ask. If you want something in there specifically, ask.
And a lot of persons in the YouTube are saying, listen, they're asking for my ideas, they don't pick me, but then I see it on the TV screen and my name is not there.
Mhm.
So, you know,
I'm not paid.
I don't have no money to show for this idea that the whole of Jamaica loves and the whole of foreign, if it goes international, loves. So we're really seeing whether it's an open call or if it's a job or whatever it is that we're doing, we're saying creatives need to think about all the ways to ensure that they're protected and have those conversations, be open to discussing what it is. Because some of it, as you also mentioned, Helen, it's not set in stone. It's not like, okay, you do it this way or you do it that way. It's really about your negotiation and what it is you want for your personal brand. Yeah.
Right.
And if you read something and you're not quite sure what it says, there's no harm in, or I don't think there's any shame or harm in saying, I want a chance to review this again and I want to read it again. Never feel so pressured into signing a document right then and there. Always say, no, I want to take legal advice, or I want to go home and quietly think about it. I want to take my highlighter and I want to highlight the parts I'm not quite sure of. There's nothing wrong with that. Always just, certainly for me, I read documents 2-3 times, and the fourth time I read it, I'm seeing something that I might not have interpreted a certain way or seen, before. So just always negotiate, always read. There's no shame in saying, can somebody help me understand this document?
Right. Most importantly, it's getting it from the person. The truth of the matter is, and a lot of things that we don't even, or a lot of times that we don't even realize, and we get intimidated by big corporate or big brands, and not realize that we can ask for the contract to be amended. You can ask for simpler language, because if you say, for argument's sake, to the person that has put out the bid or has offered you this contract, explain this line. I don't understand it. If they say to you, this is what it means in simple terms, you
put it there.
Right to say, write it in those simpler terms.
Put it in the ABC language that I understand.
Yeah. So I mean, that's something that we go through daily here, whether it be with other musicians, etc. You do reserve the right to ask for simpler language for something just once you are comfortable. And as Chanel and everybody else has been reiterating, it is integral that you understand what it is that you're signing.
And it's just very important overall to understand that what you are bringing to the table might not be cash in hand. What you're bringing to the table is an intangible asset that has value. So while big corporate might be throwing out the billions or the millions, and you think, oh, all I have is this artwork, that intangible asset can carry value and will carry value. So you have the bargaining power as well.
Because the thing is, if they could have found something else and somebody else, they wouldn't need you.
Well, sometimes they will, that's the risk you run, but it all depends. It all depends on like Helen said before, it's a negotiating power. It's understanding. And I do encourage all creatives. This is something that I can be thankful to Digital for. I did contract negotiating. It's something for you to understand when you sit in a room or sit across a table from somebody else, it's being able to speak for your property and defend your brand and say, this is my value, this is what I have to offer. And while you are giving me this, I need to be comfortable with all that surrounds this agreement. So you reserve the right to say it. It's just how you say it, because some creatives I know can be, as Colin started out with, they can be so very protective of their work, and it needs to be this way, no changes, you take it or leave it. And you have to be a little bit flexible, but it's for you to articulate how or why you think it should stay that way, but still leave room to say, all right, hey, but once both are comfortable, that's the aim of contract negotiating, for both parties to be comfortable and to leave winning. Both, not just one.
And to feel like we're both getting value from this relationship.
So as a creative, while you might not be operating in the financial sector or the tourism sector, you still have to understand the business concept. And as Sabrina was saying, don't, because your intangible asset, your intellectual property has a value, you feel like I'm going to demand all of these things. You have to be reasonable. You have to sit down and negotiate and say, okay, can we reach a middle ground for both of us to benefit? Because ultimately that's what you want, a mutual relationship with this other side, not someone you feel like you're just going to get some money or going to help them out. You both want to benefit. They want to build their brand, you want to build their brand, and you also want to maintain the integrity of both brands. So that's something to also keep in mind.
I would also add, sometimes, just to balance both sides, you as the creative want to protect your vision, your intellectual property. So, or you could also be somebody who's very timid. You're not used to saying, well, this is what I want, and you find that you don't speak up in meetings, or you're not able to articulate what you want. Get a third party to do it for you, even if it's your lawyer, or if you think you can't afford a lawyer, or somebody else who's able to say, this is what the person wants, or somebody who will say to you, well, maybe you're being a little unreasonable here. Perhaps you should look at it from this point of view. Maybe having a third party negotiate on your behalf is not such a bad idea either.
Yeah, that's where management comes in often for like artists, for argument's sake. Yeah, definitely third party.
So thank you for bringing that up, Helen, because I love to talk about how much this is going to cost me and my creatives. So, Marcus told me that it's not a lot of money to get some of these things on the road. So I'm good with that. I'm comfortable there. So, but then when I get to these words that are stressing out my eyes and my brain, and I need you and others to help me, how much chilling I need to put down for that?
That is not set in stone. Contrary to what everybody believes, people think that lawyers cost a whole lot of money, but certainly at our firm, we're very open. We're always open to discussions as to fees. Lawyers tend to be reasonable. If you say, well, this is what I can afford, you'll find that people are willing to work with you. So, you'll never know until you reach out and have that conversation with somebody.
And just to add to Helen, as it relates to the registration of trademarks, I saw a comment earlier about what is the price for a consultation. Consultations with our firm is free. You can always contact either of us via our website, milesfletcher.com, and just give us a call. We'll tell you whether or not we think this can be trademarked and what we think the estimated price would be, both on the JIPO side and the legal fee side. So as Helen says, just reach out, contact us. We're very understandable with what your budget is and your price range.
Did you see that, guys? I typed it in the chat. Free.
Okay.
No, that is consultation.
With extra ease. Hello. So,
and so I can put a plug for my organization. So while we are not legal experts and so on, we are the whole thing of business development. And people come to us, creatives come to us all the while, and we do give them, based on our experience and our understanding as well, how to go about it. And we refer them to JIPO and there are other legal minds that we work with as well, who we can engage on their behalf. But help is out there. Of course, it graduates in scale from free, so you have to pay money. And sometimes depending on what it is that you want to protect and get, you just have to make up the mind. You have to pay, and it's an investment, right? Because down the road, what you can give up, and you realize, wait, the people take my property and make millions off it, and if I had just paid a lawyer a 50,000, boy, I could have all this, but instead, you know, it was swiped from me. So we have to look at things in context. Always look at it from the perspective of a business and from an entrepreneurial mindset. We're creative, but why are we into creativity? Yeah, we love it and we do it, and we probably will give away some of it for free. But at the end of the day, when the belly starts rumble and the rain starts falling, look up and the roof leaking, you need money. Right?
You cannot see the
I
closing.
promise you that the money you pay at the beginning, if you just get legal advice, is way less than what you will incur if you need to defend somebody abusing your intellectual property or try to get someone pay you back for what they took from you. So it might seem like, as Marcus said, a lot of money for $2,000 a year, but it's way cheaper than what you would incur 10 years from now.
Or lose.
So,
Don't be penny wise
or
and
lose.
pound foolish. You know?
Thank you for the wise words that you just dropped in, Marcus.
Yeah, all time. Don't be penny wise and pound foolish. All time.
And we're not in the age of starving artists. That not keep.
No.
That is not keeping. If we're a creative, it also means that we're making our money. We're not no white squall is. We're talking teamwork, building a brand, and ensuring that you can profit from it and your family can benefit from it as well.
Mm-hmm. And don't always feel like if you're trying to think of a contract, it needs to be a 50-page contract and you just can't be bothered with that. You can just have something on 3 pages that clearly sets out your relationship. So don't think, oh, here these lawyers come with them 50-page black and white that I don't understand. No, it's better to have it in writing, and it can be done in 3 pages. So don't let it scare you.
Wow. I mean, this, I feel like if any creative that was on this chat before that thought they knew nothing about intellectual property and how to get it, you came to school and you should be equipped to go to Jaipur, to go to some of these lawyers and talk to them and say, hey, listen, I want to do this thing. I want to make sure that my art, my design, my game, my craft is protected and I can be able to benefit from all the hard work that I put into it. But I want to close us off to say, if I've created this company that is, so expansive, I do all the trademarking and I do all of that, and I now want to actually sell it to somebody for argument's sake. How do I go about the process of valuing this that I've created? Like, where do I even start?
Well, you definitely reach out to an auditing firm, because for some companies, they actually have an asset on their balance sheet that says that the value of their trademark is X. So the auditing firm will have an approach. I think there are like 4 different approaches that they take to value the trademark, and they take different factors into consideration. So once you go to that auditing firm and they value your trademark, well, not trademark, sorry, all the intellectual property, which could also be goodwill, and goodwill is just how people view your brand. Then that is how the value gets assigned to it. Based on that value, you can use it as a negotiating point if you want to sell it or license it, or just keep it on your books, because that value to the intangible asset will have the value of your company be higher than without the intellectual property. So definitely contact an auditing firm.
Wow. I think I speak for all the creators when I say I'm loving you, because boy, you have literally made us a lot of money. I mean, we are all these creators in the chat. I'm sure they're going to now go and make sure that their work is protected. Like, I don't know if Jaipur, them lock guys. You cannot call them right now. But
first thing Monday morning. Right,
I know that first thing Monday morning that there will be lots of questions, lots about this thing and how to protect their property. So, I mean, I want to thank you guys so much for breaking it down so that we can understand it, so the examples can relate it to ourselves, whichever creators we are. From comment, I'm gonna read a comment from YouTube. These lawyers are so sweet. Boy, stereotypes are a thing, eh? I tell you them.
Get a bad name all the time. You know what I'm doing.
So. I'm not
lawyers are sweet, so you know. So, not lawyers are sweet, so.
Exactly.
Well, This one include you, them say love them bad. This is
All right.
cool indeed. So everybody included in that one. Love or no? So, I mean, thank you guys so much for sharing this with us, for sharing, why intellectual property is important for creatives. And of course, I want to give you the opportunity, if you have any final words to these creatives that you want to share with them, and just to remind those of us here that you can stay in the chat and talk to each other, network, so that you can actually have some actions coming out of this meeting. But I'm gonna hand over to you guys to just share some final words with us and with these creatives who are with us tonight. You're right beside me, Shaniel, on my screen.
Okay, so I'll just say, as we've been discussing here, your intellectual property is your brand. It's who you are. It's your asset. Take it very seriously, and don't just feel because you are starting up and you're young or fresh that you don't need to focus on that aspect of your business. It's just as important as any other aspect of your business. So take registration seriously, take enforcement seriously, and just protect your brand.
Any words from Colin, Sabrina, Marcus, or Helen?
Yes, I'm going to throw in my final word, which really is helping to give a plug to Marcus and the lawyer. I did a little bit of research before coming in the meeting, and the numbers of industrial designs registered in Jamaica, to me, is woefully low, less than 200, right? For the year 2019, 117 and 3 based on some stats from WIPO. I want to encourage all the creatives who are, especially on the visual side, because industrial design protects the visual, the aesthetics of the item, not necessarily the function and so on. So I want you guys to start flooding Jaipur and registering, because from where I sit at JBBC, and we encourage people a lot, but I think people get intimidated and think the money up front is too much. It's not too much. Take your creative design, take your original design. So the fashion designers, the textile designers, the jewelry makers, footwear people, all kind of visual creation. Start registering them. You may not see the value right now, and you may put it down and sit on it for 10 years, and you wonder, wow, I myself am a creative, and many moons ago I used to print t-shirts. Now that they are going through the archives and say, you know what? I'm going to put these out on wall prints next, and I'm going to put them on different surfaces. So I'm preparing my portfolio to come knock on Jaipur door and doing some stuff for them. So be proactive, get moving, and you'll see the value down the road. You may not see it now, but you will see it.
Okay. Any final words, Sabrina?
For me, I would say just remember that, if once you register your IP, it helps to turn your business or your ideas into money makers, increases your business market value, and it helps you to stand out from the competition. Please do not forget that you reserve the right to ask for simpler, words in your contracts, etc. You don't have to sit and be intimidated by anyone. I mean, they're just another person, to be honest, regardless of what entity is behind them. Just have the conversation, and you'll be surprised how open and sometimes accommodating they can be. As you thought lawyers were all, just coming for your money, but now you learn that they're not. And just a shameless plug. But go and follow Bob Marley Foundation. We do a lot of projects with the creatives. We have a lot of murals, for example, at the museum, and from time to time we will send out bids for creatives to participate. I happen to have some insider information that one might be dropping soon, so follow our pages, look out for the call to bid. We'll be sure to share it with Kingston Creative as well, so tune in to their stuff and you will see more.
Thank you for that plug, Sabrina. Marcus, Helen, do you have any final words for us?
Marcus, you want to go ahead?
Sure. Well, I want to thank the Kingston Creative team and our fellow panelists, for putting this together. I want to also highlight, of course, the importance of investing in your creativity. Sometimes we think of IP assets as being secondary assets. We value a house and car, land, and microwave and other equipment, but we don't have the same value attached to our IP or intangible assets. And so being able to have a portfolio comprising of IP assets, right, can be just as lucrative as having tons of cars and I'm gonna say boat and airplane and such, because it's a matter of how you plan to use it and to maximize the earning potential from it. I want to finally say that Monday is World IP Day 2021, April 26th. And so we'll be having a forum from 9 to 12:30, 9 to 11:30 on Monday, and a whole week of activities next week as well. So please check us out on our website and our JIPO online on social media for more discussions along these lines. Thanks.
Okay, awesome. And where can they find that information? On your social media pages?
Yes, www.jipo.gov.jm and JIPO online, Facebook, Twitter, YouTube, Instagram, LinkedIn, the works.
Okay. Helen?
I think we as a country and as a people, we're very creative, not just, the artists, the musicians, our business ideas, our medical fields. We have so much potential as a country, and we should always ensure that we're able to protect it, we're able to monetize it, so that we can build Brand Jamaica moving forward. That's what I'm very excited about. I'm very excited to see what we can do as a people. So always just protect what's yours, what you've spent so much energy creating.
Thank you guys so much. My heart is full and my head is full of information as well. I'm sure as well as the creatives who have joined us on the chat. Thank you guys so much for sharing this information with us. And thank you to the creatives too for asking all of these questions so that we were able to, cover as much as we could so that each creative can feel like, okay, I'm a step better than I was before in protecting my work and what I've been doing. So thank you guys so much for being so awesome tonight. Thank you for joining the Kingston Creative Meetup. And of course, we're gonna, for a few seconds, we're gonna just ask persons to stay with us if you want to, so you can network, you can ask more questions. People are gonna be here. You can stay and chat. But thank you guys on YouTube. You've been amazing sharing with us, your questions, your comments. I'm glad you have a different opinion of lawyers, and I'm happy that you have the information that you need to move forward to make sure that your work is protected from here on. And I see a comment from YouTube. They say, thank you guys. This was wonderful. So thank you so much. And I hope you guys have a wonderful evening in preparation for the Monday storm of intellectual property, because they're going to come at you. Thank you guys so much and have a great evening.
Thank you too, Tavia. Thank you.
Thank you, Tavia. Yeah.
So I'll stay for a few minutes. I don't know.